Hello everyone and welcome back to the channel. My name is Shoily Chakraborty and I'm working as a legal intern in LEXIS and Company. The topic for today's video is Validity of Insolvency and Bankruptcy Amendment Act 2020. Insolvency is a situation where individuals or companies are unable to repair their outstanding debts. Bankruptcy is a situation whereby a court of competent jurisdiction has declared a person or another entity insolvent, having passed appropriate orders to resolve it and protect the rights of the creditors. It is a legal declaration of one's inability to pay off debts. The Insolvency and Bankruptcy Act was enacted in 2016. Recently, the Supreme Court has upheld the constitutional validity of the Insolvency and Bankruptcy Code, Amendment Act 2020. In its August Order 2019, the Supreme Court had held the government decision to grant home buyers the status of financial creditors. Subsequently, the government introduced the IBC Amendment Act 2020 that mandated a threshold of at least 10% of home buyers in a project or 100 of the total allottees for initiating insolvency proceedings against the real estate developer. It means that a single home buyer is barred from approaching the National Company Law Tribunal under Section 7 of the Insolvency Bankruptcy Code to initiate insolvency proceedings against the real estate developer or builder. Section 3 of the Amendment Act allows home buyers to seek corporate insolvency resolution process against builders only when 100 allottees or at least 10% of allottees make a joint application to the NCLT. The allottees should be from the same real estate project. Aggrieved allottees drawn from different projects of the same developer cannot form the 100. A 30-day deadline was given for existing applicants to find the requisite number of supporters to meet the threshold of 100, else their plea pending in the tribunal even before the commencement of the 2020 Act would be deemed as withdrawn. This was done to prevent real estate projects from being stalled by new disappointed home buyers or investors. The Supreme Court's ruling. Supreme Court said that insisting on a threshold in regard to these categories of creditors would stop discrimination in litigation. The court agreed with the legislature that having a single allottee approach the tribunal would be risky, considering that a corporate insolvency resolution may also entail a complete overhaul or replacement of the developer's company management. Such an initiative by a lone allottee would derail the plans of other allottees who still had faith in the existing developer or were pursuing other legal remedies. The amendment reflects an attempt at shielding corporate debtors, real estate developers, from what is considered would be either for frivolous or avoidable applications. Consensus of the creditors. The amendment is likely to ensure that the filing of the application is preceded by a consensus, at least by a minuscule percentage of similarly placed creditors. Allotment. It does not matter whether a person has one or more allotments in his name or in the name of his family members. As long as there are independent allotments made to him or his family members, all of them would qualify as separate allottees and they would count both in the calculation of the total allotments, also in reckoning the figure of 100 allottees or 1/10 of the allottees. Thank you. Please like, share and subscribe to the channel.